Hello, everyone, and welcome to Conversation Cafe. I'm June Robbins Foreman, your host. My guest today is lawyer Charlene Le Beau with the Justice Center for Constitutional Freedoms. I met Christine at the George Jonas Freedom Awards in Calgary, Alberta, and I learned there that she was defending a number of BC healthcare workers at the BC Supreme Court. These workers seek to strike down the BC government orders or mandate that would have them vaccinated against COVID-19 or lose employment. Welcome, Ms. Le Beau.
Hi, June. Thank you for having me.
Yes, well, thank you for giving of your time to discuss this very important case. I thought I would summarize what I understand to be the background, and then if you would fill in anything that you think is relevant, I think that would be a good place to start.
Sure.
So Provincial Health Officer Bonnie Henry made a series of orders on March 7th, June 10th, September 12th of 2022, and then another order on April 6th of 2023. And each of these widen the scope of who would need to be vaccinated to be in or near a public health setting. And by and large, there were no exceptions, not even natural immunity. And then in 2023, she extended, or she gave yet another order in July, and that rescinded part of the order so that no longer would the colleges for health professionals be obtaining personal information regarding vaccine status. However, anyone that would still seek to enter the workforce in a public health setting in BC would still need to be vaccinated. Does that sum it up?
Pretty much. The dates that you stated might not be right on.
Okay.
We focused, our petition was focused on what we call the hospital and community orders and the residential care orders. We challenged those orders. So those orders started in the fall of 2021. The two orders in the fall of 2021 were issued on different dates, but then they started to coordinate on September 12th, 2022. So those orders made it a requirement for healthcare workers who worked in government healthcare facilities to be vaccinated for COVID-19, to have taken the two primary series doses of the vaccine. And so, like I say, they started in the fall of 2021. There were several of them, and then they were continued and extended on September 12th, 2022, April 6th, 2023, and then her final order was issued on October 5th, 2023, just a few months ago. We had initially included the order with respect to the health professionals, but like you said, that order was rescinded. And I think you said it was rescinded in July of 2022. I just have to look at whether that's accurate, but that order was, yes, in fact, rescinded. And so we weren't challenging that order.
Okay, but is it my understanding correct that only part of the order was rescinded, in that the colleges were no longer needing to gather information about vaccine status, but
Yes.
Still, if a nurse or any healthcare professional wanted to work in British Columbia, they still needed to be vaccinated. Is that correct?
Yes, that's correct. But those orders are made pursuant to the hospital and community orders and the residential care orders.
Okay.
So yes, we were getting to the same place, but technically it's slightly different.
Okay, I got my information off the website, so if I'm wrong, thank you for correcting me, which, yeah, I suppose that I was. So the vaccines in question, these are the first two COVID shots, the primary series that were initially given to all of the healthcare workers. Is that correct?
Any healthcare worker that worked in a health authority facility. Yeah, so those orders didn't affect people in private practice.
Okay, so,
Yeah,
so go, carry on, sorry.
yeah, and so the regulated health professionals orders, those pertain to anybody, any health professional who is regulated by a college. So those orders would then have impacted the doctors or health professionals in private practice.
Okay, so today, if somebody is seeking to work in a public healthcare facility in British Columbia, do they need to get the first primary series? Do they need to get the bivalent? What is going on in terms of a person's vaccine status today?
Okay, so pursuant to the October 5th, 2023 order, and that is the order that's in effect right now. Any unvaccinated any unvaccinated person who applies to work in a public health authority facility must take the new XBB 1.5 vaccine. And so that's not a booster, it's actually a new vaccine.
Right,
And
right.
yeah. So the bivalent, it was the booster.
Okay.
But so the October 5th order requires any unvaccinated person who's applying for work in a health authority facility to take the new XBB 1.5 vaccine. But the healthcare workers who were vaccinated with the primary series back in 2021, they're good. They don't need to take any further vaccine. And we say that is inconsistent with
Right.
Dr. Henry's logic. Yeah.
A bit absurd, in fact, because if originally those vaccines are no longer effective, there wouldn't be a need for this new vaccine. The healthcare workers that were originally vaccinated, they don't have to take the new vaccine. Is that correct?
Yes, that is correct. And we say that's irrational. Not that we want her to mandate the vaccine on anybody, any of the healthcare workers. We don't, but we do say that it exposes an internal irrationality, because the science is clear that vaccine efficacy drops off very quickly after a few months, and that the primary series is no longer effective because the virus has mutated, or there's the new variants. And
so
yeah,
why would the people that were originally vaccinated not have to take the new one?
that's
Yeah,
right.
it doesn't make
That's
sense.
the argument. That's right.
Okay.
Yes, absolutely.
So my understanding is you did have a day in court on December 18th. Is that correct? Or did I get that date wrong?
We did have a day on the 18th, but this trial was, or hearing was 14 days, in fact, and it started on November the 20th, 2023. It ended on December 1st, and then it continued on December 18th until December 21st.
Okay, before we get to the outcome, can you just explain for the audience what your defense was? What are the laws that you grounded your arguments in?
This was a judicial review under the Judicial Review Procedures Act, and our arguments were grounded, based on charter arguments that the orders violated the petitioner's rights under the charter, under sections 2A and 7. Section 2A is the freedom of conscience and religion, and section 7 is the right to life, liberty, and security of the person.
Okay, I read the documents for the case, and one of the reasons that you gave to strike down the orders is that the vaccines are followed by adverse events in many cases, enough such that the population that these vaccines were forced upon should be taken by choice rather than by mandate. So what science are you appealing to make that argument?
Well, okay, because this was a judicial review, the evidentiary rules are very limited or very strict. The criteria is that we can really only rely on the record of material that was before Dr. Henry when she made her orders. So a judicial review is not a competition between different experts or whose science is better, and so it's
Okay.
difficult to argue the science, but within the record, which is the government's materials, we were able to find a lot of material regarding adverse reactions and the science, their own science. I mean, their own science showed that vaccine efficacy wanes oftentimes to zero after a few months. I mean, there's different studies that were in the government's materials, and some of the studies said that vaccine efficacy waned to, say, 40% after a few months, and some studies said that it waned to zero. But there's a significant amount of evidence to prove that vaccine efficacy significantly wanes after a few weeks, a few months of taking the initial series, and also after taking a booster. So we pointed out that evidence to the court. There was also significant material in the government's evidence that talked about adverse reactions. And so I did go through that information with the court. And there was also an FOI request that we were able to get into the record. There was quite a bit of debate about what constituted the record. And so that those FOI materials did go in, and those contained quite a few emails to the PHO regarding adverse reactions that people had experienced. And so that was reviewed as well with the court.
FOI being Freedom of Information Act.
Yes, Freedom of Information and Protection of Privacy Act. I guess we say FOI.
So you're saying that Bonnie Henry had within her possession information that described adverse events, and there was issues with the vaccine, and yet she still went ahead and made these orders that would have people vaccinated or they would lose their employment.
That's correct, yes.
Okay, so you brought that up in the defense, and what was the conclusion of the case, or what were some of the summaries of what their defense was?
The judge's response, he listened. I don't know how much he was impacted by it. I think the overall sense is that there's always adverse reactions to all vaccine, or there's always risks. So he has to take it into account, though, for sure, in terms of determining reasonableness. So the test in a judicial review, or the judge's role, I should say, is really to determine whether or not the decision maker, being Dr. Henry, acted reasonably in making her orders. So the judge has to take into account all of the evidence that's in the record. So that includes the adverse reactions, the vaccine efficacy, things like that, in determining whether or not Dr. Henry acted reasonably. And that's all the court can do, determine whether she acted reasonably. And if the court determines that she did not, then there's different options for the court. One of which is to remit the matter back to Dr. Henry, with directions. Okay,
so did the judge specifically say anything about this inconsistency or irrationality, as you called it, around having the original COVID vaccine and yet not needing to update that for future, and yet for future work in the BC healthcare area? Did he say anything about that? Did he break down item by item your argument and give a judgment on each of those points, or did he just come out with an overall statement?
He hasn't rendered a decision yet.
Okay.
Yeah, he reserved, And likely there won't be a decision in this case for several months, maybe the spring, or it's hard to say exactly. There was a huge volume of materials in this case, approximately 9,000 pages. And so he listened to everything that was presented to him. He challenged both sides on different issues. For example, he challenged he challenged the government's lawyers on the fact that there was no process for applications for religious or conscience objections. So he certainly recognized the coercive component to these orders, in that the workers either take the vaccine or lose their jobs. He was very cognizant of that, and the fact, like I said, that there was no process for people to apply for an exemption based on a religious or conscience objection.
Okay, and can you talk a little bit about the charter? I read in some of the documents that you said the charter is the highest law in Canada and nothing should supersede that. So could you talk about that approach to defending your clients?
Well, Section 24 sub 1 of the charter states that anyone whose rights or freedoms as guaranteed, I'm just reading directly from the section,
Right.
as guaranteed by this charter, so anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. And so we say, and the petitioners say, that their rights were violated, their charter rights were violated, and Section 24 permits them to then make an application to the court.
So what then would be the counter argument to that? The limits on freedoms? What would their...
Yes, and so that's the government's position, is Section 1 saves it. Section 1 of the charter reads that the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So that's what the government is relying on. They say, okay, well, they say, first of all, that their rights were not violated. That's their first position. But then they say, in the event...
How do they manage to say that their rights are not violated?
Well, they made arguments that the religious petitioners did not satisfy or prove the nexus between their religious beliefs and their objection to the vaccine. And they also stated that those petitioners who had conscience objections did not meet the test for a conscience. And so they said that their rights weren't violated. But if they were violated, that Section 7, it saves them in that the orders were justified because we are in a pandemic. And so Section 1 allows a person's rights to be violated if it can be found, that it's reasonable to do so, or, that it's justified.
And then you would counter that argument with the unreasonableness of the mandate based on the criteria that you already laid out.
Yes, that, and yes, and in addition, there were some other inconsistencies in the application of the order, which made it irrational and unreasonable. And those are, one, that in the orders, they allowed for construction workers and other occasional workers like vendors or technical specialists to enter and work in health facilities without showing proof of vaccination. And if they did not show proof of vaccination, they needed to physically distance and wear a mask. So there was accommodation, or there was an allowance made for those workers, and yet there was no such allowance made for the petitioners, and several of our petitioners were administrative workers and or remote workers working from home. And so those workers were not entering facilities. They were not having contact with vulnerable populations, and yet they were fired. And yet the construction workers and the other occasional workers were allowed to work in facilities. And so there's a real contradiction there. It's not logical. And the other inconsistency was that two of the health authorities that we're aware of, they offered employment, or sorry, they offered contract employment to remote workers, to remote working healthcare workers, and they were not subject to the vaccine requirement.
Right, so a completely different standard for them than for the people that you're defending, right?
Yes, and those workers, those contract remote workers, could enter facilities approximately once per month. And so that's completely illogical, in relation to some of our petitioners who were remote workers who didn't enter facilities. I mean, maybe very occasionally they might have had to, but I'm not sure if it would have been, probably less than once a month. But in any event, they were fired because they didn't show proof of vaccination, and yet these contract remote workers did not have to show proof of vaccination. So that was another inconsistency in the application of the orders.
For most of the applicants, were they remote workers, or what was the ratio of remote to on-site?
We had 11 petitioners, and 6 out of the 11 were either remote workers, administrative workers, or both.
Okay. My next question is, what about the other provinces? Does that have anything to speak to this issue? My understanding is that there's a number of provinces that have hired back their unvaccinated workers. First of all, is that correct?
Well, I don't know about whether they've hired them back, but to the best of my knowledge, there's all of the mandates across Canada have been lifted with respect to the healthcare workers. The certain provinces like Ontario, they leave it to their particular hospitals to implement vaccination policies. There was quite a bit of discussion about that at the hearing, actually, about what was in place in different provinces, because you can't, I've done the research, and you try to look at each province and see, but usually they're silent on the issue. You might find some news reports that talk about a mandate being lifted, but there's nothing really official that you can find. No one report that sets out who has a mandate and who doesn't. But it was generally agreed that there were no mandates in Canada except for in British Columbia with respect to the healthcare workers, except that in Ontario, the hospitals could impose their own policy.
Ms. Le Beau, why do you think there's a silence on this issue?
You mean why it can't be researched? I don't know. I mean, it's like the official, government websites just have dropped it. I can't comment on what their motive would be. I don't know.
In the UK, they have discontinued the vaccine program altogether at the end of December. And just recently, the Surgeon General in Florida said that because of DNA being found, or contaminated vaccines with DNA found, it's absolutely horrendous that we would continue this program. So there's a number of scientists, researchers, doctors on the ground that are all saying, hang on a minute. My question is, what right does a health a public health officer have not to take into consideration opposing points of view when this is such a drastic imposition on people, albeit they are desiring to keep the public safe. But when there's various points of view, how can the public be assured that all angles or perspectives about the vaccine and their possible adverse events, how can the public be assured that a health officer has taken all that into account?
Well, in her orders, Dr. Henry says that she has taken into account various perspectives or the ongoing evolving science. She does say that, and that was argued, and that is in their record, that the various different science. And like I say, there was science and reports and studies that talked about adverse reactions and efficacy of the vaccine and things like that. And I think the overall conclusion is that the government says that the vaccine is safe and effective. That's they just continually say that, and that it protects the public health and protects the employees, the workers, things like that. So
right, even though the original vaccine and the people who originally got the vaccine don't have to update their vaccinations.
That's
Not
right,
that
and
they
in
want
fact,
them to have to, but if the argument is we're keeping up with the science, it would follow that the people that were originally vaccinated with a vaccine that is no longer effective would indeed have to be vaccinated with the updated one. And
yes,
yet she's not requiring that.
that's right. Right. So it's again, it's irrational and it's illogical, and I can't answer that. All I can say is that that is what Dr. Henry says, and that is what their argument is, and they point to the science in their record that the vaccine is safe and effective, even though there's lots of evidence that shows that it isn't. And so what can the public do to know that Dr. Henry is keeping up with the science, and that and trust what Dr. Henry says? I don't know. I all I know is that she does keep up with the science, and her conclusion is that it is safe and effective, but other people don't agree with that. So
Yeah. It's interesting to me. I've been thinking a lot about what it would take for the public to regain trust in public health. And I think one of the things is to vigorously pursue opposing science, opposing perspectives. I interviewed a Dr. Jan Bhattacharya back in August, and he experienced Francis Collins phoning Anthony Fauci and saying we need to have a public takedown of these fringe epidemiologists, meaning himself, Senator Gupta, and Martin Kulldorff. They wrote the Great Barrington Declaration. These are not lightweights. These are people from, Harvard, Oxford, Stanford. They have a different perspective, not necessarily on the, Dr. Bhattacharya said the vaccine saves lives, but I really respect and appreciate the fact that he also said, we need to take into consideration the lockdowns. And now we know that in a sample size of 40,000, what happened there is vastly different from the, several billion people that took the vaccine. So it sounds like he is updating himself continually on the science, and many other doctors and scientists and researchers are doing that as well.
yes.
And it's actually shocking that there's not more of these transparent discussions between opposing conclusions and researchers. And I think public health would do well to have more of that, and to be open and transparent, and actually invite the discussion rather than censoring and suppressing.
Yes.
It's so shocking to hear, these public health officials saying we're gonna shut down these opposing points of view when their information can be so relevant and help to shape the entire program. And even look at the vaccine. I don't know what it means to have foreign DNA in a vaccine, maybe it means nothing. But the guidelines put out by the FDA and the World Health Organization allows so much of DNA to be in a vaccine. And there's an article that just came out in Ontario, Canada, that's saying there's testing of the vaccine that far exceeds what's allowed according to the regulations of the FDA. Yeah, I wanted to say that because I think the audience needs to understand that one health officer making an order that impacts the lives of healthcare workers who worked tirelessly through the pandemic and then were kicked to the curb. I think there needs to be more accountability on.
The overwhelming evidence is that vaccine efficacy falls off very quickly. But you know, there is evidence in the record to show that the vaccine works. So it's really for the judge to determine, not it's not a correctness standard, it's a reasonableness standard. So the judge can only determine whether or not Dr. Henry acted reasonably based on the information that was before her, good and bad. You know, looking at it all, was she reasonable in issuing these orders? If she was, then there's still, the judge still could ask that, could direct that she provide a process for exemption.
Right, right.
If he finds that she didn't act reasonably at all on the preponderance of the evidence, then he could cancel the orders. The mandate of the PHO is to protect public health and to protect vulnerable populations. And we agree that those are good objectives. And those people should be protected, and our healthcare system should be protected. We agree with that, and we stated that in court. We felt that the application of the orders was overbroad, and we felt that the orders were irrational and unreasonable in certain respects. And so we are hoping that the judge will see that as well, and will find accordingly.
Yeah, so we wait.
Yeah, I mean, our you know, primarily we're asking that the orders be canceled. Yes, we would like that, because we don't want to see a mandate on the healthcare workers. We think that they, you know, their right to personal autonomy over their health decisions is very important.
Right,
But,
especially when you can see, yes, there's efficacy for the vaccine, but there's also some risks involved, and those risks are being investigated more and more. And whereas one time, you know, for example, myocarditis, so that's a conspiracy theory or that's misinformation. Many of these, well, I won't say many, but some of the risks have proven, yes, in fact, there's something going on. I just listened to Mr. Dalgleish, Dr. Angus Dalgleish, and he just was found to quote that the increase in excess deaths correlates, not is caused by the vaccine, but is correlated with the rollout of the vaccine. Wouldn't it be incumbent on healthcare professionals to say, wow, that's enough evidence such that we need to investigate this? You know, some of these things are so much more reasonable than, in my mind, than just saying, well, you know, we can see it's safe and effective, safe and effective. Yes, you know, Dr. Bhattacharya said it saves lives. Very fair enough. But on the other hand, why not include and be open to investigating what might be an increase in excess deaths? If it's more than a correlation, and in fact it is a causal, we'll never know if people are not open to saying we need to at least look at what these scientists and doctors are saying.
Yes, I agree. It is incumbent.
Sorry, go ahead.
I was going to say, I agree. It is incumbent upon the provincial health officer to look into that and to look at all aspects of this medical procedure, especially given that it's something that she's mandated
Mhm.
in order to work.
Yeah, well, Ms. Le Beau, thank you for your time. Thank you for defending Canadians in seeing that their rights and freedoms are upheld and are considered in this incredible pandemic. And yeah, thank you for your time
Well,
and
thank
your
you very
service.
much. No, well, thank you. I appreciate
Okay.
it.